So, Allie, everyone in our field is talking about something called Chevron deference. Can you just tell us what that is?
Yeah, so this Chevron Deference Doctrine comes out of a Supreme Court decision during the Reagan era, and it states that federal agencies are able to interpret statutes from Congress related to the regulations that they're working on. And at the first, this was really championed by Scalia and other conservative justices on the Supreme Court, because at the time the Supreme Court was quite liberal, and so they could take power away from the liberal Supreme Court and give it to the agencies to very narrowly interpret civil rights legislation that was happening. And then as we move into the many administrations later, the Obama administration, the Chevron deference doctrine is used by courts to uphold things like greenhouse gas regulations and Dodd-Frank Act regulations. And so Scalia and his allies on the court start to no longer like the Chevron doctrine. And so that brings us to today. So Tom, do you want to tell us a little bit about what happened with the Chevron doctrine this summer?
Right. So, according to these justices, it used to be good and now it's bad. And so there was a case brought to them a couple of years ago called Loper Bright, and they decided it just this summer, and they basically completely nullified the Chevron doctrine, and they threw interpretation of ambiguous ambiguous statutes back to the courts. Now, this is very convenient because it basically, like all the time since the original Chevron ruling, there's been this effort to stack the court with conservative judges, with judges who are anti-regulation. And this is, from lower federal courts all the way up to SCOTUS. And so all of a sudden, you've got what is basically a judicial power grab. And one of the justices who voted against this ruling was Associate Justice Elena Kagan. And she put it, really succinctly that with this case, the conservative majority on the court turns itself into, quote, the country's administrative czar. So basically, what you have here is a power grab, taking away power from federal agencies and the experts that they hire to, sort of your EPA type of people who, they hire scientists to interpret these rules, and putting it right back on the courts at a time when the courts are very, very conservative.